Good evening, dear brothers and sisters, for watching my YouTube channel. Before starting dictation, I would like to convey you that at the end of the dictation, you will find the outlines and phrasal outlines of the words used in the dictation, which will help you in case you are not able to write the dictation very well on account of not being well aware of the right and precise outlines and phrasal outlines of the words. Firstly, note down the dictation. Ready? Start. It was also noticed by this court that on the basis of aforestated sale deeds in question, the parties concerned had got their names mutated in the revenue records and were in possession of their respective portions. Full stop. The appellate court also noticed that the suit for division of holding was instituted after about 14 years from the date of execution of the sale deed. Full stop. Taking into consideration the fact that it was only on the basis of the boundaries described in the registered sale deed that the vendee could claim a right of possession, and it was not a case where the parties were claiming division on the basis of their respective shares in the ancestral property, it was held that the observations made by the court below insofar as merits of the case were concerned, were legally untenable. Full stop. In addition to above said, since the court below had decreed the suit ex parte without granting opportunity of hearing and of adducing evidence to the appellant within bracket respondent number 6 here in bracket close, and thereafter rejected the restoration application cursorily in terms of the order dated 27/12/2021, it had committed a manifest error. Full stop. The appellate court, having come to the aforestated conclusion, held that it would be appropriate for the court below to pass a fresh order after giving due opportunity to the parties concerned to adduce evidence and to present their case on merits. Full stop. Accordingly, the orders dated 26/10/2019 and 27/12/2019 have been set aside, and the case has been remanded to the court below for grant of an opportunity of hearing and for adducing evidence and for deciding the case afresh on the basis of merits. Full stop. An objection has been raised by the counsel appearing for the state respondents and also the counsel appearing for the private respondents with regard to the entertainability of the present petition, which seeks to assail the order dated 18/11/2022 passed in the appeals by the respondent number 2, by pointing out that the petitioner would have an efficacious statutory remedy of filing a revision against the said order, before the Board of Revenue. Full stop. Counsel for the petitioner has sought to refute the aforestated preliminary objection raised on behalf of the respondents by submitting that since the appellate court had remanded the matter to the court below without any observation on merits of the case and without setting aside the findings recorded by the court below, it was a case of a single inverted comma remand simpliciter single inverted comma close and therefore the remedy of the revision would not be available. Full stop. In this regard, reliance was placed on a decision of this court in Ram Bhajan and others versus Deputy Director of Consolidation, Allahabad, and another to submit that an order of a single inverted comma remand simpliciter single inverted comma close would be of an interlocutory nature, and a revision against the said order would not be maintainable. Full stop. Counsel appearing for the private respondents has controverted the aforestated submissions by drawing attention of the court to the observations made by the appellate court on merits of the case, to point out that the court, while deciding the appeal, has considered the reasoning assigned by the court below and remanded the matter with observations on merits, semicolon. Therefore, the order cannot be said to be a single inverted comma remand simpliciter single inverted comma close which can be held to be an interlocutory nature and not amenable to the remedy of statutory revision. Full stop. Learned counsel has referred to the decisions of this court rendered in Mahendra Singh and others versus Board of Revenue UP and others, and Jhinka Devi versus State of UP and others, on the scope of the revisional powers under the Revenue Code. Full stop.